I'm going to talk to David Lowe, who heads up our commercial contracts team, about what changes in English contract law there have been over the last 18 months. So David, you've been doing these commercial law updates for some time now. What are there in terms of recent trends?
Well, of course, every year there are cases about liability, for example. Penalties are another area. And then we have big issues like good faith, for example. But the thing that's been common for every time I've done this contract law review is how many of the cases are arguments about is there a contract at all, and battle of the forms types of cases. And it occurs to me that actually we're not that great at managing risks in organisations on contracts, because the contracts that are generating the problems and risks typically are not the ones that in-house legal have been involved in. They usually survive. It's the below the iceberg that struggles. I think assiduous training, especially to senior managers, on the importance of using subject to contract when you don't intend to form a contract is really important, because all too often directors and senior managers of companies seem to end up sending inappropriate emails and finding them stuck in a contract they didn't want to end up in. And then the other area is on incorporation of terms. In the old paper days of 15 years ago, people used to be very good at my terms and conditions of sale shall apply, and at least having the opportunity to have the battle of the forms. But many of the recent cases show that people have forgotten about that and have forgotten how to incorporate terms in an electronic world to protect their businesses.
So can you now incorporate standard terms by reference to a website?
Yes, is the good news. We always thought you could, that as long as you were very clear how you did it, that you should be able to refer to a website and say, subject to terms and conditions on this website. But we've now had a case that actually says that does work. I think the judge said something like, in this day and age, why should you not? So it's very strong guidance that incorporating by way of a website is good. And in that case, on the website page, there was actually 3 different sets of terms and conditions. And he didn't even have a problem with that. He said it's pretty obvious, it's a warehousing contract, it's going to be subject to the warehousing terms and not the freight terms, and therefore they apply. People should be careful though. I mean, if you incorporate by reference to your website, make sure the link works. In litigation, somebody's going to argue that the link never worked, the terms were never there, the site was always under construction and so forth. So you do need to keep archives of your websites, records of your websites and so on. But as long as you do all that, it will work. And I heavily recommend it in an electronic world as a way of speeding things up.
When you last did an update, I seem to remember that good faith was the hot topic. Have there been any updates on good faith?
Yes, you're right, Sarah. We had a Yam Singh case which said good faith could be implied into contracts, which struck a big shudder of fear around the business contracts community. We then had the Compass case, which suggested that an express right to use good faith may have meaning. But then the Court of Appeals did say yes, but, and narrowed it considerably, and also raised questions about the Yam Singh case about whether that was actually good law. But then we've had a run of cases since then that have generally sought to not apply good faith. So it was TSG in building services, where the contract allowed a right to terminate on 3 months' notice without reason, and the court said that you didn't need to use that in good faith. There has been one case involving a training manual for pilots where the courts did decide to imply a duty to use good faith, but it was a pretty unusual relationship, and so it suggests that there's quite a high watermark now to imply good faith term, which is encouraging news.
Have there been any recent cases on excluding liability?
We haven't had one of those cases. We have had a couple of interesting cases on exclusion of loss of profit. There was the Fujitsu and PwC contract where there was a total exclusion of loss of profit, direct and indirect. Fujitsu then claimed that that meant they were left with no remedy, and that's unfair, unjust, and therefore shouldn't apply. The court very quickly kicked that to touch. They said you have very clearly excluded loss of profit, direct and indirect. In fact, it's a mutual exclusion which you put in because you, Fujitsu, wanted it, so don't be surprised if it now comes back and bites you when you want it the other way around. And I mean, there's some difficulty to that case. The court said that Fujitsu did have some remedies. It was able to recover payment of historic invoices, which is good news because sometimes we spend hours arguing about whether an exclusion of loss of profit excludes payment of the invoices. And also suggested that Fujitsu might have had some other remedies, such as asking PwC, which had become IBM, to account of profits, which I think is a bit strange. but generally a robust support of the contractual wording. There has been another case on exclusion of loss of profits, which is a reminder that in minimum purchase obligations, that if you exclude loss of profits, you may well be excluding your remedy there if somebody has failed to purchase. However, the court quickly identified that the loss of profit in that case only excluded indirect loss of profit. The clue was that they put the word indirect at the beginning of the sentence. So funny enough, the court said this only excludes indirect loss of profits. Therefore, it didn't exclude direct loss of profit. So no groundbreaking clauses, but cases that do remind us the importance of getting the detail in these clauses right. It is well worth reviewing your standard exclusion clauses and making sure they're up to date.
If there's a foreign party signing the contract, what things need to be considered?
I think as commercial lawyers, we often forget that if you've got a foreign party to an English law contract, the foreign law might still be relevant. Many of us avoid getting the extra cost of the foreign legal advice because it often doesn't tell us anything that's surprising and often be quite expensive. But there's been a recent case involving two Swiss parties to an oil trading contract subject to English law, where under Swiss law one of the parties claimed they had signed in a way that made the contract invalid. And the courts looked at it and said, well, in assessing whether the company has signed in accordance with local company law, we have to have a look at local company law. And if local Swiss law says it's not a valid signature, it's not a valid signature, and therefore the whole contract is invalid, even though it was subject to English law. So it's a real reminder to us that ideally you should get foreign legal advice if you've got a foreign party, although you've got to weigh up with the cost benefit. If you're regularly trading in other countries, make sure you've got a broad understanding of the execution required in that country to avoid bespoke advice.
I gather there have been a few cases recently where the courts have looked at inconsistencies in contracts.
Yes, we're all familiar with the situation. We've got a beautiful front end to the contract, but we've never seen the back end. We've never seen the commercial schedules, the payment structures and so forth. They all come in on midnight the day before signature, and you have a quick flick through them and insert them and cross your fingers a bit, really, to be honest. And one of the ways we've all got comfortable with that is putting a precedence clause into the contract, making it clear that the front end overwhelms the back end if there is ever a dispute. And we've had two cases now on that point about how do you deal with a precedence clause. So if you've said the front end will always take precedence to the services specification, if there is an inconsistency, does the front end entirely trump the schedule? And interestingly, the court have said in both cases, before we go to the precedence clause, we read the entire contract and try and make sense of the entirety. And only then, or if we've left with a question on a particular point, might we consider going to the precedence clause. So it's not a Schedule A or Schedule B applies. They'll put Schedule A and Schedule B together, find the little error and only concentrate on that and then deal with that and take that away from it. So that precedence clause, I'm afraid, is rarely going to be relevant. The courts are going to try very hard not to use it. Counsel perfection, you've got to make sure your contracts are consistent, but we all know the challenge of doing that with the substance of the commercial schedules.
Do we have any greater clarity now on what's a reasonable termination notice?
Yes, it's always a difficult question, isn't it? Badly written contract, not clear what the termination clause says. How can you terminate? Are you locked in forever? 1 month? A year? And the classic question, because the legal answer is if it's not clear, you can terminate on reasonable notice. What could that mean? Hemsard and Boots was about children's wear being supplied to Boots. Hemsard had been the Phoenix vehicle that came out of Adams Children's Wear. It had actually gone bust several times. Boots then gave 9 months notice to terminate. The supplier said, oh, that feels a bit short. Under the old contract with Adams Children's Wear, which we are all complying with, it was 18 months. Why shouldn't it be 18 months? And the court said, well, firstly, you never novated the agreement over. So that old agreement is of historical interest only, doesn't apply to the new relationship. Nobody is applying that. So 18 months is irrelevant. Therefore, the court had to look at what's reasonable and was 9 months notice reasonable. And the court said 9 months is more than enough. It's more than a season of children's wear, which is what they thought would be a reasonable period. And therefore, yes, Boots, you have properly terminated this contract. And supplier, you've now been disappointed.
And do you have any advice on how to effectively manage the transfer of a contract?
Well, the Boots case is an example of how not to do it, is that the supplier had taken over from Adams Children's Wear, but they had not made any attempt to say, hey Boots, the older contract applies. If they had said to Boots, can we all agree that we are now trading on exactly the same terms as the old contract, or even better, done a novation with the old company, the new company and Boots, then it would have been absolutely clear what the contractual terms are. But because they didn't bother, they just assumed they didn't get away with it. And so my advice would be always try and make it clear to the other party what you think the contractual terms are, because you will then kick it to them to either deny or agree.
Are we likely to see any changes in late payment?
Yeah, it's a very big topic, and it's interesting as a contracts lawyer to find this potentially being a manifesto issue in the forthcoming UK general election. We've seen a series of large corporates being challenged about their payment terms. It's an increasing trend that organisations are stepping to 90 or even 120 days payment terms. That's now attracting a political attention. The current law in the UK says your payment terms should not be beyond 60 days, but they can be beyond 60 days so long as they are not grossly unfair. What's grossly unfair? Nobody knows. The government guidance at the time the legislation comes in provides no help, and there is little guidance as to whether it should be 90 or 120 days. The government has now recognised that this lack of clarity is potentially causing this problem, and that if they want to help small and medium-sized businesses with payment practices, they're going to need to do something. BIS has gone out to consultation on strengthening the law, which I think could have the result that 60 days will be the default period unless you've got a very, very, very good reason, and hopefully we'll have clarity on how good a reason it needs to be to step out of that. They've also introduced obligations for larger companies to report on their payment practices so they can be held accountable publicly, and they're also looking at changing the UK government-sponsored prompt payment code to make it clear that prompt payment means payment within no longer than, say, 60 days. My prediction would be over the next 12 months, depending on the nature of the government that gets elected, is that we'll have legislation making it difficult to pay beyond 60 days if you want it to be enforceable. But so what anyway? What does the law matter in this area? People who are suppliers will not take litigation to enforce against an ongoing contract. The only way this is really going to change is if trade associations and regulators take enforcement action. And will they have the stomach for that? That's to be seen.
I've read a bit about the modern slavery bill. What impact will that have?
Yes, Sarah, it's not something you typically find yourself discussing in a commercial contracts review. Modern slavery, very important issue for human rights purposes, but why is that relevant to businesses? It's become relevant to businesses because as the modern slavery bill has gone through the House of Commons, House of Lords, they have introduced a transparency requirement requiring businesses to report on what they have done about reviewing their supply chains and ensuring there is no modern slavery in their supply chains. The idea is that companies above a certain level of size would have that obligation to report in their annual report. There's currently a Home Office consultation out there saying what size of company and what sort of measures should they be required to comply with. If I'd been asked what kind of size of company, I'd be saying large multinationals who probably already doing this anyway. So I'd be saying, I don't know, a worldwide turnover of £200 million plus maybe. Well, the Home Office has said, should it be a company larger than 35 million or more? Now 35 million, that is a relatively small business in my world, and that feels like a fairly onerous obligation. Therefore, I'd encourage all businesses and trade associations to respond to the consultation saying, well, if it's going to be for large companies, then we should make it very much very large companies and set the threshold accordingly. Importantly, companies will have the ability to simply say in the annual report, we have done nothing. That's allowed as an option, so a company might choose to not check its supply chain and simply make that statement. But the whole point of that is to therefore attract the bad publicity that will inevitably follow for higher profile companies to encourage the change.
David, there's always a